Okay, so today we're going to talk about seller forms. And we're going to start out with the exclusive right to sell listing agreement. We have a few different types of listing agreements. I'm going to go over this standard form that's for any property that has an improvement on it. We also have a form that's called exclusive right to sell vacant land or lot listing that you would use if you were selling a vacant lot. But the lot has to be platted. So in other words, it needs to be recorded at the courthouse as part of a subdivision or something like that. So there are a few small differences in the form, but it's usually in regards to septic, well, and water and sewer and that kind of stuff with regard to a vacant lot. So with that, we're going to get started with this. And of course, as soon as I get started, my dog wants to go outside. So give me 1 second. I'm going to open this door. It never fails. Okay, so usually if I'm going to take a listing, the first thing that I do is pull up a tax record or a tax card on the property, so I have that information to fill in with either with this listing form. So I'm going to go to Flex, and I know that some of you haven't had training on Flex yet. Flex is our MLS software. In fact, Wednesday morning from 9 to 11, I teach Flex basics. So I'm sure I'll see some of you in that class. So if I would go to any listing here, can you all see the screen for the Flex? Or is it still on the?
No, I can see the Flex.
Okay. Sometimes for some reason, it doesn't work. So I would go here to the list to a listing, or I would go here to my menu and scroll down to taxes and select CRS simple search. And here is where I would put my address. We'll just use my house as an example. And you'll see as you start typing, usually the choices come up. And then I will hit my search or submit. You'll notice that on the tax record, it's going to show you a picture of the last time it was in the MLS. And for my particular house, it was a vacant lot for sale. So that's why you see this sign. Over here is the map that shows me my lot dimensions. And then if I scroll down here, it will have the current owner and mailing address, and then some parcel information. So I'm going to go back to my form, and we're going to start filling this out together. So the first blank on the form is the exclusive right to sell listing agreement is entered into between, and the first name is the sellers. So that would be me. And again, my real name is Joanne, by the way. My nickname is Jody. If I go back to the tax record, this is where it shows the current owner name right here. Now, well, let me go back to this and then I'll cover that. So if there were two of us that own the property, the first name would go here and then the second name would be here. And then the firm name would go in this as the listing firm. So this would be Keller Williams. You can select Innovate or Realty. Either one of them is a legal name for us. So don't get caught up on which one to use, because either one is acceptable. So in this box here in blue, it talks about whether the person that recently owned the property is now deceased. Of course, when you would look at the tax listing, it would show the deceased person's name as the owner. But it could be that the will designated someone else to be the owner once that person died and the tax record doesn't get updated. So if you're not sure about who should be listed as the seller, you can always reach out to me and we'll try to figure it out together. Or they may have hired an estate attorney, and that estate attorney could direct you on who should be the name of the seller on any documents. So the next section talks about the effective date. And this says the seller represents that as of the effective date, the seller is not or will not be, if the property is currently listed, a party to a listing agreement with any other real estate firm regarding this property. So this is basically saying, I don't have it listed with anybody else, or by the time this listing agreement comes into effect, it will not be listed with anyone else. And then it also says that the seller agrees that they have received a copy of the Working with Real Estate Agents brochure and have reviewed it with the firm or the representative of the firm, which would be you. Number 1 talks about term of the agreement. So how long is this listing agreement in place for? So it will begin on the effective date, and we'll talk about the effective date here in a minute. And it will end at midnight or at 11:59 p.m. on the expiration date. The effective date is the date that the seller and the firm's representative signs it, the agreement. So here we go again, right? I know that there are people who try to manipulate the system, and they will get the seller to sign the listing agreement. And because of the rules around the MLS and when a listing has to be entered into the MLS, the agent holds off signing it for a few days until they get, or sometimes longer than that, until they get their stuff together. And that's really not, I hate to use the word legal, but it's really not ethical. This listing agreement is not enforceable until everyone signs it. So the MLS rule is that once a listing is taken, it must be entered into the MLS within 3 business days. However, if any public marketing goes on, so if you put a sign in the yard or you post it on social media for the public to see, or you send out flyers or anything like that, that's considered public marketing. And the National Association of Realtors has come out with a rule that's called Clear Cooperation Policy that says that any listing that is marketed must be entered into the MLS within 1 business day. And what they're trying to prevent is what we call pocket listings. So a pocket listing is when an agent takes a listing and they market it and they try to find their own buyer for it so that nobody else can see it and sell it until it's already under contract. And that's a big fat no-no. And there's a hefty fine for that if you're found guilty of manipulating the system and not being adhering to the clear cooperation policy. So the idea here is that the day that the seller signs it should be the same day that the agent signs it. And then there's another box here that you could check if this is the case. And that is, let's say the property is already listed with another firm and it expires on Friday night, for an example. This says you can sign a listing agreement with a seller who is currently under contract with another listing agent, but the listing will not, this agreement does not go into effect until that one expires. And so that expiration date would go into this first blank right here. So let's talk about ethics for a minute. I know you all haven't had ethics training. That comes when you do your orientation with the Board of Realtors. But it is against our code of ethics for you to solicit business from someone who is currently under contract with another agent, unless that person reaches out to you. So if you get a call from someone who says, I currently have my property listed with ABC Realty and I'm not happy with their services and it expires on Friday, and I would like for you to list it when it expires. That's perfectly legal. You can make an appointment before Friday and go out and go over all the documents and go ahead and list that property. And this agreement would not be enforceable until Friday night at 11:59 p.m. But you would have the documentation in place and you would be considered under contract with that person at the time that you've actually met them. So you can't call them, but they can call you. C talks about the expiration date. So I see anywhere from 6 months to a year for a listing agreement to be in place. In this market, if it is a house or a condo or a townhome and it's priced right and in decent shape, it's not going to last more than a week or two, if it lasts a day, depending on the price range. So, but what I usually see is 6 months, and maybe for land or properties that might be a little more difficult to sell, I would see a year. So here you would enter the date. So if we went 6 months out, that would be October the 5th. And we'll go ahead and just check that box. Pretend that it's not listed with someone else. Number 3 talks about the, this is your property address and your legal description. So the address that we're using as a guinea pig today is 8204 Lantana Lane. And it usually comes up here and you can pick it. And then it asks for the legal description. This is where you get it from the tax record. So I've gone back to see the tax record. Can everyone see this tax record? Yes? No? Maybe?
Yes.
Yes, thank you.
Yes, we can.
So the first thing I see here under my tax record is this parcel ID or tax ID. So I'm simply going to select it and copy it. And then I'll go back to my form and I'll look here to say, okay, here's the PIN, PID, or other identification number of the property. That's my tax ID. So I will paste that number right in here. Okay. Now I'm going to go back to the tax record. And I'm going to find some other information here. So if I keep scrolling down, I'm going to have my legal description. So my legal description is Lot 5R, Kirkland Estates. So I'm going to copy that. And then I'll go back to my form. And that will actually go here in under other description. And I'm going to paste it in here. And now I have the information here that I can fill in up here. So my lot number is 5R. There's no block or section number. And the subdivision is Kirkland Estates. Okay. So in New Hanover County, we don't really use plat book or slide book and page number very commonly, but you will see it a lot in Brunswick County and Pender County descriptions. So it's okay for you to leave that blank. When you go to enter this listing into the MLS, it's going to ask you for a number. If you don't have a number because it's in New Hanover County, you can put zeros in there. But if you're in Brunswick or Pender, you should put those exact numbers. And then it says some or all of the property may be described in deed book. And this is a deed book and page number. This is where when the seller bought the property, was deeded the property, it was recorded in that place. So if I scroll down here to when I purchased the property, which was in 2012, why don't I see my deed book and page number? Interesting. It's usually right here. Under, oh wait, no, that's a whole other report. Wait a minute. Here we go. I can find it under my mortgage history. And this is deed book 5945, page 14. Actually, it's up here under my sales history. The last recorded deed, it was a quitclaim deed. And the last recorded deed is 5945, page 2467. So that's 5945. Page 2467. Okay, I'm going to go back to the tax record so you can see that again where I found that. So it's under sales history through today. Now, when the lot was first purchased here, it was in my name and my mom's name. And then in 2016, we did a quitclaim deed and took my mom off of the title. So this is when I became the full legal owner of the property. And there is the deed book and the page number. Anything blue that's underlined, when I put my cursor over this, you see how it gets underlined? This is actually a hyperlink, and I could go right to it here and look at the deed. It would take me right to the county website to show me a copy of the deed. So there's a lot of good information on this tax record. We're not going to review it today, but we will go over it a little bit more in MLS training on Wednesday. So I'm going to go back to my form, and I have my legal description in here as well as my address. And now I'm going to scroll through. So this next section talks about fixtures and exclusions. So a fixture is a an item in the house that is going to stay with the property. So anything that's permanently attached to the house is considered a fixture and will stay unless it is listed in this section. So this goes through commonly considered fixtures that sellers may or may not think are fixtures, but it gives a good list. And I would recommend that you review this with them. Sorry, I had to sneeze. Because this might strike some conversation about things that they plan to take, like grandma's dining room light fixture. Oh, that's not going to stay. We're taking that with us. Okay, that's fine. Just you have two choices. I always recommend that they go ahead and take it down now and replace it with something else that matches the style of the house. So then there's no question. So that a buyer doesn't walk in and they say, oh, the only reason that I'm even interested in this house is because of that dining room fixture. And that's always the way it happens. If they say that it doesn't stay, then the buyer says, oh, but I want it and that's the only way I'm going to buy it. So I always recommend that they go ahead and take it down, or things that they plan to keep, they go ahead and take down. And then there's no question. It doesn't mean that they can't leave it up though and list it as an exclusion. So if I go here to this next page, it has D, items that are leased or not owned. And then there's E, other items that do not convey. So if the seller was planning to take grandma's light fixture in the dining room with them, they would list here dining room fixture. Okay. And that's perfectly legal to do that. This will also be entered into the MLS when you enter this listing, so that any buyer's agent will see it and know to list it on the offer to purchase. If you have any items that do not convey and you get an offer on the property, please look closely at that section of the offer to purchase and make sure that whatever the seller plans to take with them is listed there. Because I see so often where the agent will say, well, it was in the MLS. Well, that's not what the seller signed, and that's not what the buyer signed or understood. So the offer to purchase is the governing document when it comes to closing and what stays and goes. D is this leased or not owned. So common things that would be listed here would be a gas tank, a propane tank, maybe a satellite dish or satellite equipment, receivers and that. If you go back here to this page, there are lists there. Again, there's a very detailed list of things that would you might want to consider not staying. And so the first thing here is alarm and security systems. They are considered attached. So,
Jody,
yes,
where does the Ring doorbell come in?
that's exactly what I was getting ready to say.
Oh, okay.
So this specifically calls out doorbells and chimes. So a Ring doorbell is considered a fixture unless you list it as an exclusion. Okay. Garage door openers, it's common that they end up disappearing. Oh yeah, well, they moved to California and they took it with them in the car that they were driving. You can replace those with universal garage door openers, but technically that is something that should go with the property. Generators that are permanently wired, not the one on wheels in the garage that you can hook up when we lose power and just wheel it around. But it's permanently wired generators are considered a fixture. Invisible fencing, trees and landscaping. So maybe they have a bush outside that they got from their grandma's garden in the country, and they want to take it with them. Again, I say, dig it out now, put it in a pot and replace it with something else, or just fill in the hole. That way there's no question or no concern about what should stay and what should go. Mailboxes, mirrors attached to walls. So commonly in a bathroom, you'll see a mirror that is at the sink. Some people use mirrors that they buy from a store that are frame mirrors that look just like a picture. They are considered a fixture because a mirror in a bathroom, because bathrooms need mirrors so you can get in there and fix your hair all pretty and get your makeup on. So make sure you review this list with your seller so that there are no questions about what they are going to take and what they're going to leave behind. But I'm glad you brought up the Ring doorbell, because that's a common point of contention when the seller didn't read this section of the listing agreement and it was not listed as an exclusion, and the buyer thought it should stay, which according to this section of the listing agreement, and by the way, this section is exactly written in the offer to purchase.
Yeah, because it's linked, the Ring is linked to like a specific account. It's also linked to like emails and stuff like that. So I was
That's
just
right.
wondering, it seems more personal, but it does specifically say doorbells.
Yes,
So
it does.
yeah.
So what it also says under C is unpairing or deleting data from devices. So prior to closing, the seller shall unpair any devices that will convey from any personal property devices, hubs and intelligent virtual assistants, mobile devices, vehicles, etc., which they are paired. Delete personal data from any devices that will convey, and restore all devices to factory default settings unless otherwise agreed. So this is saying that the Ring doorbell needs to be unpaired from the email address or phone in which it is attached to. So the simple thing to do is just list it here as an exclusion. Other items that do not convey, Ring doorbell. Okay. And then everybody's on the right playing field. Other questions, comments? Okay. So the next section is personal property. So
Is
if I
there
go back to my list here and I look and I say, it says all stoves, ranges, ovens, built-in appliances, attached microwave oven and vent hood. Those are all considered fixtures. So I don't need to list any of those in my personal property. So the most common things I see under personal property is refrigerator, washer, and dryer.
Did anybody else lose Jody's screen?
Up.
Do you all have Jody's screen? You
Can
have it?
everyone see this?
Yeah, I have it.
Yeah, we have your screen on.
Okay.
Okay,
It's Nancy's computer.
just me.
She just had a bunch of work done on it this weekend, so of course it won't work right.
So I'm gonna just log back in, Jody.
Okay, sure. So personal property are things that are not considered fixtures that the seller intends to leave behind. So those are the most common things: refrigerator, washer, dryer. Sometimes you'll see curtains or drapes. Now the curtain rod that's attached to the wall is considered a fixture, but the curtain itself is personal property. Okay. Now, if you're selling or if you're listing a property that's a beach house that's coming fully furnished with everything in it, including dishes and silverware and all that stuff, this box here in the blue says, any personal property that will be a part of the sale should be identified in this paragraph. Buyer is advised to consult with buyer's lender to assure that personal property items listed above can be included in the contract. So if the buyer is getting a financing and they're including all of the furnishings and the towels and the sheets and all that other stuff, those things should probably not be listed here under personal property. You would probably need a separate bill of sale. And what I would recommend is that the seller make a long list of all the items that they plan to leave. And then they can create a bill of sale. You cannot create it yourself because you're not an attorney, for one, and you're not a party to the transaction, but they are a party to the transaction, so they could create this list. And then you could provide it to the buyer so they would know exactly what was planning to be left. Number 5 talks about a home warranty. A home warranty is a good selling tool. It actually provides coverage for a buyer for 1 year from the date of closing that takes care of any defects in future defects, not existing. So it doesn't accept things that are wrong in a home inspection, for example, but things that happen after closing to any of the appliances, the HVAC, plumbing, and electrical. So it's your systems. It doesn't cover the water heater for 30 days usually, but it does not cover the roof or any structural issues. It's only systems. Okay. So if the seller agrees to pay for a home warranty, then it would be marked here as far as agrees. Or if they don't agree, they would check this box. If they do agree, then I would recommend in your listing presentation, you may have examples or brochures from 2 or 3 different home warranty companies that they can review and select a company and a policy to purchase for any future home buyer. The cost would go in this line here, and that would need to include taxes. So if the warranty price is $500, but they charge 7% in tax that has to be paid at closing, then the total that they would agree to pay would be $535. The next section is, so some warranty companies will offer the agent a commission or a referral fee if they sell one of their warranties. A few of the companies quit offering that, and they say they pass it on to the savings on to the seller or the buyer, whoever's paying for the warranty. And so if they are offering a referral fee, I usually turn it back in and get the discount on the warranty for the seller. So in this line, I put 0. So let me go ahead and mark that. Say we're going to offer a warranty of $535. And that covers the warranty stuff. I would go ahead and order the warranty now because there are things that will help to cover for the seller if they broke down during the time the property is listed. So I encourage you to read through the brochures for each of the warranties and it will share with you what is covered for a seller during the listing period and what is covered for a buyer once the property's closed. Either way, it does not get paid for until closing. So it's a good tool for a seller to have in place, because they're not paying for anything when it first gets listed. They don't pay for it till closing, but it does cover them for some things. Number 6 is listing price. So what kind of price tag are we going to put on this?
Range.
So let's say we're going to list it for 550,000. And then what are my terms? So I've never known anyone to not want cash. So I always select the cash, the cash option. And in this case, I would also select conventional. Now, the loan amount for VA has gone up. I'm not sure exactly what it is. It's probably close to 500. So you can select FHA or VA, but just know that depending on the price, it might not be an option. When you wouldn't select VA or FHA is if the property that you were listing was in a condition that maybe had some safety issues or that needed some updating with some structural problems, that an appraiser that would do an appraisal for a VA or FHA loan would not pass the property. So that's when you would not want to check either of these two. So I'll go ahead and check them. Loan assumption depends on the kind of loan that the seller has. All conventional loans today are not assumable. FHA loans and VA loans are assumable, but they have to qualify. So the buyer, if they were assuming a VA loan, the buyer would have to be a veteran and have eligibility to purchase under their own VA status. Then you have a box for seller financing, and that's owner financing basically. And then there's an other. So other would be a USDA loan. USDA is a government loan that is 100% financing. It's based on income. So the buyers, depending on family size, so let's say a family a size of 2 could not earn more than 96,000 and change. So you could say this would qualify for USDA. If you look at in the MLS, and I'll show you where those are on Wednesday, there's a link to a website you can go to, and you'd have to enter the address of that property to find whether or not that property was eligible for USDA financing. So not only does the buyer have to qualify, the property needs to be in an eligible area for USDA to finance it. Okay. All right. Number 7, firm's compensation. So this is where you'd put in the commission rate. So let's say we're going to say 6%. There's also this long line that allows you to enter something other or. So I see a lot of different things here. Sometimes it says, let's say I offer my seller that I'm going to list it for 6%. And if another agent sells the property, I get 3%, they get 3%. If a buyer comes along and they use me to write the offer, then perhaps I would offer you a 5% rate. So this is where I could write that out. Then it goes into detail and describes when the fee is earned. So the biggest thing coming out of this is that you don't get paid till it gets to the closing table. So there's no expense to a seller to list a property. So this goes through and explains when the fee is earned and when it's paid. Number 3 talks about, let's say a person comes and looks at the property 5 days before the expiration date. And the property expires, and then that person decides they're going to come back and make an offer. No, paragraph number 3 says that the seller agrees to honor the listing agreement for X number of days after the expiration if someone who we showed the property to came back to buy it. So this is a protection period. Usually I see 30 days, sometimes I see 60 days in here. But it does have a requirement that the listing agent has to provide the names of those people and deliver them or postmark them to the seller within 15 days after the expiration date. So let's say Nancy comes and looks at the property 5 days before it expires. And then it expires and the seller does not relist the property with another firm. And Nancy contacts the seller directly and says, Mr. Seller, I can go ahead and make you an offer on the property. The seller can say, great, but just know I still have to honor the listing agreement that I had with ABC Realty because they provided me with your name that you had looked at the property while it was still under the listing agreement. If the seller has listed it with another firm, then you're out of luck. ABC Realty just doesn't get paid. Nancy could go and renegotiate or negotiate an offer, and the new firm that had it listed would be the firm to be paid. Questions on that? Okay. C talks about when the fee is due and payable. I'm not going to read all this to you. What I will tell you is you all need to read these documents because you're asking your sellers or your clients to sign them, and they should also read them before they sign them, because probably 50% of the questions that I get from agents when they need help, the answers are right here in this document or in one of the documents that they signed or that their seller signed. So please read it. And then if you have questions, I'm happy to answer those questions for you. D talks about transfer of interest in the business entity. So if the seller changes the name on the deed basically, and they change it from their personal name to their partnership or LLC, that it doesn't necessarily pay you a commission. Maybe they just sell, one of the sellers sells a portion of their interest, then that commission would be prorated based on the percentage of interest that that person is selling in the process. Then there's C, additional compensation. So let's say the seller decides to offer a bonus to the selling agent if the property's under contract by March or May 31st. Then there's another document you would fill out, and this allows for that money to be paid at closing. then there are attorney fees and costs. If there is a dispute and we have a legal proceeding brought to by the firm against the seller to recover any of or all of the fee, then the firm shall be entitled to recover from seller reasonable attorney fees as well, and court costs if the firm is found the winner in the lawsuit. Hopefully we never get there. Number 8 talks about how we're going to pay another agent or another firm. So one thing we'll cover on Wednesday with the MLS basics is that the MLS was designed and created probably 100 years ago in an effort to create a compensation agreement among firms that are members of the MLS. So Keller Williams is a member of the NCR MLS. Century 21 is a member. Coldwell Banker is a member. Intracoastal is a member. Blah, 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 blah. You have many, many members. The MLS creates that compensation agreement so that every time an agent from one of those firms goes to show a property that's listed with Keller Williams or any other firm, they don't have to negotiate how they're going to be paid should their client purchase the property. The MLS creates that agreement in itself. This basically says how much is the seller willing to pay a buyer's agent if they bring a buyer. And there are 2 ways they can be paid. One is they agree to cooperate with a buyer agent representing the buyer and offer them the following compensation. In many cases, the listing fee up here is 6% right here. So most cases, they offer half of that to the other side, right? To the other cooperating agent. So you would check that box and you would enter 3%. This first one says cooperate with sub-agents representing the seller and offer them following compensation. So a sub-agent of a seller, if you don't have an active buyer agency agreement with a buyer and you write an offer for that buyer to purchase a property, then you are a seller's agent. You're one or the other. If you don't have a written agreement with the buyer, then you are a sub-agent of the seller. So is the seller willing to pay that? And if so, what would that be? So you would check that box and maybe they say, hey, I don't care. I'll pay whoever brings me a buyer, I'll pay them 3%. The last box here says cooperate with and compensate other cooperating real estate firms according to the firm's attached policy. We don't have a separate policy at Keller Williams, so you should never check that third box. A lot of people think that this first box for a sub-agent of the seller is for a buyer's agent that is not a member of the MLS, and that's not the case. That's simply someone who is writing an offer for a buyer that does not have a written buyer agency agreement with that buyer. So I'll give you an example. I have a new listing and one of you decides you're going to host a open house for me at my listing, right? If a buyer walks into that open house and they say, oh, I love this, I want to buy it. And you say, great. And you pull out a buyer agency agreement and you start going over that and they say, no, we don't want you to act as our agent. We don't want you to be a buyer's agent, but we want you to write up the paperwork. Okay. If I had nothing listed under this sub-agent of seller, then you would not get paid. So a lot of people do that. They'll say, yeah, you can write it up for me, but I don't want you as my buyer's agent, right? Why they would do that, I have no idea, but they do it a lot. They think they know, a lot of times consumers think they know more than we do. They heard that on TV or they read it somewhere. Number 9 talks about the firm's duties. So these are the things that we are required to do. Number 1, we have to honor the Realtors Code of Ethics. Number 2, we need to use our best efforts to find a buyer. And this talks about what we can offer. We have to disclose any material term. We don't disclose any material terms of an offer. So if I received an offer on this property and another buyer came along and wanted to make an offer, I could not disclose any information about that first offer to that next person or to their agent. It is strictly confidential. Even if the buyer is one of my buyers, if I have a written buyer agency agreement with them, I still cannot disclose anything about any terms of an offer. C talks about disclosure of material facts. So what this says is whether my seller tells a buyer or not that they flooded during Florence, if I know they did, I have to tell. And I tell the seller that when we're listing the property. You don't have to tell, you can check no representation on a residential property disclosure if you don't want to share any information about the condition of this property. That's your right. But if I know of anything, I have to tell. I know that you guys had training around some of these things. So some of the questions that I get are, if a sex offender lives down the road, do you have to tell that? And the answer to that is no. If someone died in the house, do I need to tell that? No. It's strictly material facts that have to do with the property itself. If the refrigerator ice maker doesn't work, yes, you have to tell that. All right. And then D, I love this one because it protects you and you need to pay attention to it. It says that, Mr. Seller, you're hiring me to sell your home, to be your listing agent as a real estate professional. I am not an accountant. I am not an attorney. I am not a home inspector. I am not a surveyor. I am none of those other things. So if you need special help with those things, you need to hire that expertise to come and look at the property and determine what the issue is. You're not hiring me for that. You are hiring me to be your real estate professional. Okay. And then E says providing agreement to listing service. So this acknowledges that you're entering it into the listing service or the MLS. In bold print, the next thing covers fair housing. By the way, April is Fair Housing Month. Good thing to pay attention to. But this says I cannot discriminate for any of these reasons: race, color, religion, sex, national origin, handicap, or familial status, or any party or prospective party. Further, realtors have the ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. So HUD has its own rules about what you can and can't discriminate over. This first section is HUD. The last two is something that the NAR has put into their code of ethics that we also have to honor, and that is sexual orientation or gender identity. And there's a place here that the seller needs to initial. Questions on that? This form was created in last May, so almost a year. And this was a newly added thing here where the seller had to initial this. So whenever you see something added and something initial that requiring an initial, that means that there were problems or that people didn't understand that. So obviously there's still in today's world people who have broken fair housing laws with regard to these different classes of people. Number 10, marketing. So this says I will submit pertinent information of the property to the listing service that I'm a member of. B talks about commencement of marketing. So when are we going to start marketing this property? So I have a couple choices. As soon as I sign this listing agreement, or that we sign this listing agreement, I can start marketing the property. That means I'm not delaying my marketing. I'm starting the marketing right now. And we're going to start showing it right now. This says, let's say the property was a rental and the seller is finishing up painting and cleaning up. So they say, you know, it's just not going to be ready to be shown for 2 more weeks. So you say, okay, so we click this box and then we look at the calendar and we pick a day 2 weeks out. So that would be the 19th that we would start marketing the property. It's totally fine. Our MLS allows us to 2 different kinds of delayed marketing. We have one that's called coming soon, which allows us to put a sign in the yard, to put anything on Facebook or on your website or anywhere saying, this listing is coming soon. It will be available on April the 19th to be shown. I can market it, but I can't show it. That's the rule around coming soon. Then there's this delayed marketing where we're not doing coming soon that does not allow you to market it. So delayed marketing literally means I'm delaying all marketing on this property. When I get this listing agreement signed, I still have to put it into the MLS within my 3 business days, even if it's delayed marketing. A delayed marketing listing can only be seen by you and the staff. So you don't have to worry about other agents knowing that it's coming on the market or seeing that it's coming on the market because you're delaying that marketing. A coming soon listing is also entered into the MLS within 3 business days, but agents can see it. Just the public cannot. So if you go into the MLS, and I'll take us over there for just a second. If I look down here under my hot sheet, which is any status change over the last 24 hours, I have new listings, I have canceled, I have closed, expired, blah, 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 blah. Then I have new coming soon listing. There are 7 of them. If I click on this, I, as a member of the, oops, sorry, my battery's dying. I gotta plug in my cord here. As a member of the MLS, I can see any coming soon listing that is being offered. I just can't show it. You see here it says coming soon, no showings. If I click on this listing and I read it and I go down to the end, this tells me what the delayed marketing date coming soon is. So it will be available to be shown on 4/30/21. Up until that point, I can see it in the MLS. It does not get sent to realtor.com or to Zillow or to any of the other syndicated websites, but it does show for other agents that are members of the MLS to see that it is a coming soon listing. Okay. All right, I'm going to go back to our form here. So now it says, I want to read what's in this blue box. It is in the best interest of most sellers to get the highest possible price on the best terms for their property, and maximizing exposure of their property advances that interest. Accepting an offer on the property before it's fully exposed to the widest group of potential buyers may deny the seller the best opportunity to attract offers at the highest price and best terms. So this is telling the seller, you know, don't take the first offer that comes along without it being marketed through the MLS and these other syndicated websites, because you might get something better. C gives you a place to mark whether you have permission to do these things. So a sign, yes. Open house, sure. Advertise on other than on the internet. So can I put it on social media? Sure. Coming soon advertising. So are we going to mark this property as coming soon on April 19th? Or are we going to hide it from everyone until April 19th? So that's the box that you would pick. By the way, it can only be in a coming soon status for 30 days. If it's going to be longer than 30 days that the property won't be available for showing, it would have to go in as a delayed marketing date and not coming soon. And then the last box is internet advertising. So this allows you to put it online, to put it through the MLS with all the third-party syndications that it offers. You can put it on, it will go to KWRI, to the Keller Williams national website, et cetera, et cetera.
So social media does not count as internet advertising?
So it could. It could. Advertising other than on the internet would be mailing flyers out, sending postcards, putting a sign in the yard. Well, that's advertising other than on the internet, although it has its own block. Telling people about it. So that's really more of the advertising other than on the internet. I guess social media and Facebook would be considered internet. So down here, then it says, note, NCAR Form 105 may be used to limit or prohibit internet advertising and explains how such limitations may or may not be effective. So you may get a seller that says, I don't want my house showing up on the internet. I don't want people knowing that my property is for sale. And I don't want it out there on the internet for people to be able to see what kind of furniture I have in my house or what kind of personal belongings I have in my house. You have that sometimes, right? So that's fine. You'd use Form 105 to fill that out and have the seller and you sign it saying that they understand that they're not going to put it out on the internet, and these are the pros and cons of doing that. D talks about a lockbox. Does a seller allow you to put a lockbox on or not? If they say no, that means that either they have to be there to let the person in or you have to go let the person in. So just beware, it could create more work for you. Seller acknowledgement acknowledges and understands that while the marketing services selected above will facilitate the showing and sale of the property. There are risks associated with allowing access to and disseminating information about the property that are not within reasonable control of the firm. So once we take pictures of the house and we send it out, it gets syndicated, it's very hard to pull them back in because you don't know where that ends up. So any information you put out there, as people know, right, for other reasons, you can't always pull it back. So this just that says the seller acknowledges that that could be the case. This next section in red says that while a seller might have cameras in the house for security, they can record a person's movement through video, but they are not allowed to record audio on those cameras. You have to have a person's permission to record them through audio, and they are not giving that permission just by coming to look at the house. F talks about office exclusive. This is a listing that it can only be sold by the office, by anyone in our office, and that's in your local office, not all of Keller Williams in Wilmington and Jacksonville and Ocean Isle and Oak Island, et cetera, et cetera. It's only the office where the agent is located. It does not get syndicated. So it isn't seen by other agents other than the agents in our office.
Jody,
Yes,
can we go back to the previous point? of,
sure.
Not, they're not allowed to listen in.
Mm-hmm.
That's on the inside, right? Or is that on the outside as well?
So it just says on the property.
Okay. Do you guys ever come into any sort of problems with the ring situation?
That's a good question. I have not heard anyone complain or say anything about that. And I know that it has the ability to video and audio tape someone at the front door.
Yeah. All right. Thank you.
This section also shows in a buyer agency agreement. So when you're reviewing a buyer agency agreement with a buyer, I tell them, look, they're not supposed to be recording what you say, but it doesn't mean they're not, and we would never know it. So limit your conversation and your comments, assuming that Big Daddy is watching, right? Don't walk in and go, oh, that's the ugliest color I've ever seen in my life. Unless you would say it if the person was standing right there. It also talks about taking pictures. So there is a section here that gives permission for people to take pictures as they're looking at the house, but it's reasonable views. So don't go in their bathroom and take a picture of the soap that they use, or don't go in and look in their jewelry box and take pictures of what's in the jewelry box. This is, I'm taking a picture of the living room so I can see, I can share it with maybe my significant other that couldn't make it today, kind of thing. Then 11 talks about earnest money. So earnest money is a deposit that the buyer makes that is held in escrow on their behalf by either the closing attorney or the buyer's firm. At Keller Williams, we do not hold escrow funds. We don't have an escrow account. So whenever you enter this listing, under agent remarks, you would enter KW does not hold earnest money. Please make check payable to buyer's closing attorney or buyer's agent's firm. If there is a dispute about who would get the earnest money if a deal fell through, the money would then be turned over to the clerk of courts following written notice to parties. And if there is a dispute, the seller directs firm to disclose seller's last known mailing address to the escrow agent upon request to enable the escrow agent to comply with the notice requirement of such law. So this gives you permission to share their mailing address with the escrow agent so they can file it with the clerk of courts. Number 12 talks about seller representation. So the seller saying we are or we are not in a flood zone. And we do or we do not carry flood insurance. B talks about synthetic stucco, which is also known as EIFS. That says, as far as they know, there is or it was or was not any synthetic stucco on the exterior of this house. And then C talks about the owners association. So if there is a homeowners association, you would check this box and you would type in the name of the association manager and their address and phone number. And then if they have a website, you would enter it here. There are two here. So let's say up here, you entered the president of the association's address and phone number and contact information. Down here, it would be the association manager. Then number 2, new construction or the residential property disclosure association disclosure is not required. So if the property is new construction, or if the house is, or the property is not required to have an owner's association disclosure statement, then the seller agrees to promptly complete an owner's association disclosure and condominium resale statement addendum. So that's a special form at seller's expense, and to attach it as an addendum to any contract for the sale of the property. Okay. So if I'm selling a vacant lot, I don't have to have a residential property disclosure because there's no house on it. But whoever is buying it needs to know that there is a homeowners association and know what it's covered. So this is saying that the owner or the seller is willing to fill that out and sign it, and you would upload that as any other addendum to the contract if you were to receive an offer. Then this talks about the authorization for the HOA to release information to the closing attorney or another agent with regard to the seller's statement of account, master insurance policy, that the restrictions, rules and regs, articles of incorporation, bylaws, current financial statement, et cetera, et cetera. Then D talks about whether or not there's a termite bond on the property. So you check whether there is or is not. If there is it transferable? So just because there is a termite bond doesn't mean that the termite company will transfer the bond. Most bonds are only good for 10 years. So if it's the 10th year and that seller is selling the property, it's very likely that that company is not going to allow the bond to be transferred to the new owner. But if they are, you'd enter the amount of the transfer cost and then the name of the company that holds the bond. So I always call the company myself and verify there is a bond, and verify that it is transferable, and verify the amount that they charge to transfer that bond. Then E talks about ownership. How long has the seller owned the property? At least 1 year, less than 1 year, or maybe they don't own it yet. Maybe it's under contract to be purchased, but they want to go ahead and list it again because they might be doing a bunch of work to it or something. Or they got such a great deal that they're going to turn it around and make money real quick. F talks about receipt of sample forms. So the seller here just acknowledges they received a copy of an offer to purchase and contract sample form or a professional services disclosure sample form. You don't have to give them one. This just says if you do give them one, have them acknowledge it, but you don't have to. Then G talks about any current liens. Is there a mortgage on the property or not? And then the name of the lender, the approximate balance, the lender's phone number, and the lender's address. If they have a first mortgage and a second mortgage, then you would list the second here. And if they have an equity line, then it would be on this last section. This goes on to say that the seller is current on all payments for the loans. They're not in default. Are not other liens secured against a property for any income tax liens or real property taxes or anything like that. There are not any judgments against the seller to affect the property. And there are no UCC code fixture filings affecting the property. And if there are, then here is where you would list it. Specify any information, including approximate balances required by seller representation through 2 through 6. And then it says bankruptcy. Is the seller the seller is or is not under bankruptcy protection, or they're not contemplating seeking bankruptcy protection? Access, the property has legal access to a public right of way. If the access is private road easement or other, the seller further represents that there is or is not an agreement regarding the maintenance of such private easement or other means of access. So if the property is in a neighborhood where the HOA manages the maintenance of the roads, those roads are considered private. But usually in the HOA documents, it says that the roads are private and the HOA will maintain the roads. That's okay. You would check, yes, there is an agreement. If you're selling a property up in Pender County on a little dirt road, there's a good chance you don't have a road maintenance agreement with all the people who live on it stating that they maintain the road. So that's where you would check is not subject, or I'm sorry, there is not an agreement. So on Wednesday, I'll show you how you check as to whether a road is public or private. The next one talks about lease. Is the property subject to a lease? So is there a tenant in place, or has there been a tenant in place? You would check yes or no. And then if there is, the seller agrees to promptly provide firm a copy of any such lease, and who is the management company that manages the rental, and you would put that in here. The next section talks about FHA appraisal. Has there been an FHA appraisal done in the last 4 months? And if there has, you would check those boxes, one of those boxes. If there has been an FHA appraisal, let's say they had it under contract and the buyer was going to get an FHA loan and they did the appraisal, and for whatever reason the deal fell through, then we would need a copy of that appraisal, or at least know who the lender was, so that if another buyer came along that was getting an FHA loan, we could assign that FHA file to the new buyer. Because when a buyer goes in and applies for an FHA mortgage, they're given like an account number. And if they fall through, that account number follows that property, not that buyer. So there's already an FHA account number assigned to that property. If a new buyer comes along, we have to reassign it with that new buyer's name. Special assessments. So let's say a special assessment is a fee that a government entity or an HOA may charge every homeowner in that neighborhood or on that street. And you would list any assessments that you knew of here. Manufactured mobile home. Is there a manufactured home on the property? And if there is, then you would need a VIN number here. So the vehicle identification number would go here. Or a make and model if the VIN number wasn't known. Now, I will say this. If a manufactured home has been converted to real property, then there's no need for a VIN number here. But there's a process that you have to go through to determine if it was turned into real property. So that's when you just come see me. That's the easiest way for now. Then the next one talks about a fuel tank. So the best of the seller's knowledge, there is or is not a fuel tank located on the property. And if the answer is yes, is it owned or leased? And who is the owner of the tank if it is leased? And then where is it located? What kind of fuel does it hold? What's the refilling schedule? Who is the vendor? And et cetera, et cetera. And then this is another place if there were two tanks. So it allows the same questioning for tank number 2. 13 talks about the seller's duties. So they're asked to make the property available for showing. They will complete all the disclosures required, the Residential Property and Owners Association disclosure, the mineral oil and gas rights, lead paint. If the property was built prior to 1978, then there's a chance that there was lead paint used in that house, and we would need to disclose that. Again, making the property available for showings, providing firm as soon as reasonably possible copies of the following documents: restrictive covenants, bylaws, articles of incorporation, etc. of the owners association, title insurance policies, attorney opinions on title surveys, covenants, deeds, notes, and deeds of trust. Some of this stuff you'll be able to pull through the county website, but things like a survey or a flood insurance policy or elevation certificate, those are all good things to have if a seller has those. This gives a closing attorney permission to use a previous title insurance policy to get a better rate for the buyer. This also gives them permission to access information from the homeowners association. And immediately referring to firm all inquiries or offers it may receive regarding the property. So if the house goes up for sale and Keller Williams sign is out in the front yard and the seller's neighbor calls them and says, "I see you have your house for sale. My daughter might want to buy it. Can you just sell it to her?" Well, yeah, if they work through my agent. So this says that they will not show the property on their own. They will refer any potential buyer to you. This also says that they will provide a general warranty deed, which is the highest form of ownership in the state of North Carolina. Then it says that the seller represent that the seller has a right to convey the property. And there are currently no circumstances that would prohibit the seller from conveying fee simple marketable title as set forth in the preceding sentence, except as follows. So if they inherited the property, but their sister is also in the will to receive a portion of the money, then that would be, you would need that sister's signature on this listing agreement. But that would be an example of some kind of circumstance that would prohibit them from providing full marketable title. If any sale of the property may be a short sale, consideration should be given to attach this form. So a short sale is when a seller owes more than the property is worth, and the bank or their lender agrees to take less than what is owed to avoid a foreclosure. Short does not mean it takes a short period of time to get it approved, because it does not. It could take months to get a short sale approved. The next talks about the home inspection. Is the seller going to get their own home inspection, whether they agree or not agree? And then if they do agree, within how many days of the execution of this agreement will they get their own home inspection? And then if you provide a copy of the questions and answers on home inspections, you would check that box. 15 again talks about photographs and other materials. Basically says, as far as, just so you know, I'm going to take pictures of your house, and they're going to go on the internet. 16 is additional terms and conditions. So if there's anything else that needs to be a part of this agreement, this is where you would put that. Then 17 talks about dual agency. So dual agency means that the buyer's agent and the seller's agent, the listing agent, work for the same firm. It could be the same person. It could not be the same person. It just means that they work for the same firm. So this talks about the role in dual agency, the seller's role, and then if the firm shall become a dual agent, the seller waives all claims, damages, losses, expenses, or liabilities other than for violations of the North Carolina real estate license law and intentional wrong acts arising from the firm's role as a dual agent. Seller shall have a duty to protect seller's own interests and should read any purchase and sale agreement carefully to ensure that it accurately sets forth the terms which seller wants included in said agreement. So if you are acting as a dual agent in this transaction, the seller is basically representing themselves with regard to looking out for their best interest. You have just become a facilitator of this transaction. And this is where they would initial. Now, if they don't agree to dual agency, then that also means that another Keller Williams agent could not bring a buyer, and we have over 300. So do they want to limit themselves to only have agents from other firms bring buyers? Do they want to get rid of 300 plus other agents that might bring a buyer? Probably not. So you can offer them a designated agent option. And this means that if I'm representing you as a seller's agent and another member of my firm brings a buyer, we will act like we work at different firms. So I will not share with them any pertinent information about you personally, and they will not share anything personally about their buyer to me. So this is a good option. Number 18 talks about mediation. If there is a dispute about how to settle a disagreement, then we all agree to go to mediation. 19 talks about wire fraud warning, and this again is just like the fixtures and exclusions. It's the same box that's on every just about every document. You'll have a buyer or a seller sign. It basically means you as an agent, you stay out of being in the middle of any transfer of wiring instructions. If the seller is going to have their proceeds wired to their bank account, you let the attorney and the seller figure out how to get that money there. You stay out of it. And then number 20 says, this is our entire agreement, and any changes or termination will be done in writing. And there's a form for that. And then the seller's name would appear here. They would sign here and date it. You would fill in their contact information and their address. If the seller is an entity, so let's say the property is owned by an LLC or a corporation or anything like that, then you would not fill out this place up here. You would fill out here as entity seller, and by would be the person's name that would be signing, and then the date. I'm sorry, this is where they would sign. The name, their name would be printed here, the title that they hold with the organization that they are representing. So if it's an LLC, maybe they are the managing member or the president or the administrator or whatever. That's what you would type over here under title, and then their contact information. And then down here is our information. So the name of the firm license number. And by the way, our firm license number is C as in cat 26008. C 26008. The firm's phone number, so the office phone number would go up here, then the office address. Your signature would go here, your license number here. It would date it as to whenever you electronically signed it. It would fill in your name down here, or you could type it in, and then type in your phone number, your fax number, and your email address. Phew. All right, so that's the listing agreement. Now you know why we get paid the big bucks, because that's a lot of stuff to cover. And that's just the beginning. Then the work starts with getting the property sold. So what questions do you have? None? We got it, right?
Until we need it.
Until you need it, I know. And I didn't mention in the beginning because I didn't want you all to get freaked out, but you will not be an expert in filling one of these out until you've done it probably 10 or 15 times. So don't feel like you should know all this stuff already. What I will ask you is that you please read it. So I am happy to help you fill one of these out. When you get your first listing, it's like, oh my gosh, how do I do this? I will help you any way I can. But just promise me that you'll read it before you sit down with me. Because I guarantee you most of the questions you'll find the answers in this document. Okay, no other questions?
No other questions. Thank you, Jody.
Okay, I'm gonna share one more document with you. We have 15 minutes left, so I want to go through the residential property disclosure because I find where a lot of people are not having their seller complete it properly. So this is a form that every seller in North Carolina should fill out who's selling a property with an improvement on it, a house on it, or a condo or a townhome. And it basically says, Mr. Buyer, this is what I know about the property. It either works, it doesn't, or I'm not telling you. So you would enter the property address here. The owner's names would go here. And then this is where they would sign it once they complete the information. So the Real Estate Commission puts this form out, not the Realtors Association. And there are a couple things that you need to know about it. One is, okay, so on the second page, the property address will automatically appear here, and then you would enter the legal description. So this should be filled out by the seller. It doesn't mean that you can't ask the seller as you're sitting in front of them in person, going through the document together, and whatever they tell you, you can mark that. But it has to come, the information has to come from the seller, because the seller is the one signing saying, this is what I know about the property. So they've got three choices with each of these statements. They can say, yes, there is something wrong, or no, there is not, or no representation. No representation means I'm not willing to make any representation to the condition of the property with regard to that item. Okay. Sorry, it'll stop ringing in 1 second. So number one is the year the dwelling was constructed. They would fill that out. Is there any, or they don't know, so they hit no representation. Then what are the exterior walls made of, or what is the siding on the house? And they would check the appropriate box here. And then this is where I see where people miss. What is the dwelling's roof covering? What year was the dwelling's roof covering installed? So how old is the roof? If you don't know, say unknown, whatever the case might be. So I see where a lot of people miss that. They just leave it blank. Then down here, it talks about the dwelling's heat source and then the age of the system. If they think it's 10 years old, just put approximately 10 years old. They don't have to know exactly 8 years, 7 months, and 3 days, right? This is an estimate, but you can say approximately this amount of time. And the same goes for the cooling source. So age of system. So often they check what kind they have, but they never enter the age of the systems. Again, they would go through this and mark the appropriate boxes. If they say, I'm not telling them anything, I've never lived in the home, and this happens quite a bit with rental properties. I have not lived in the home, so I'm not really making any representation. They can check no representation all the way down. On page 2, it picks up with any infestation of bugs, any drainage problems, any structural or mechanical changes. Again, they can check no representation all the way down. If they know there's something wrong and they want the buyer to know it, they would check yes. And then down here under number 31, it says, if you answered yes to any of the questions listed above, please explain, and you can attach additional sheets if necessary. So again, you can check the seller can check no representation, but that is a red flag to a buyer that says, you better get your own home inspections and you better check these things out yourself, because the seller is not making any claim to the condition of any of these things. We had this happen this weekend. where number 29, it says, is the property subject to a flood hazard or is the property located in a federally designated flood hazard area? It was left totally blank. The seller did not check yes or no representation. The buyer found out from a neighbor that they had 2 feet of water in the garage after Florence. Guess what? The buyer wanted their due diligence money back, which was a big fat check. It was a big amount of money. The seller didn't make any representation. They didn't fill it out, and the buyer signed that they received a copy of this. So technically, there was nothing to stand on. If it were me, I would take this form, send it back to the listing agent and say, please have your seller complete number 29 on the residential property disclosure. Even if they check no representation, that would tell me, well, they had problems with water somewhere. I may go ask the neighbor, not me, I would have the buyer do more due diligence before I gave them a big fat due diligence check to find out how much water had actually gotten into the house or garage or wherever, or how much of a problem it was before I gave them any money. So again, if there's any blanks left on here and you're representing a buyer and it comes in, there's no reason you can't send it back to that listing agent and tell them you want it completed before the buyer submits their offer. This page talks about any additional fees or expenses that the HOA might have. And then if there is an HOA, what does it cover? And you would check the appropriate box, or the seller would, excuse me. And then they would initial at the bottom of each page. So that's the residential property disclosure. It's so important, so important. When I have an agent come to me and they say, oh, my buyer's all upset, they found out there was something wrong with the property and the seller should have told them. The first thing I say is, what did the property disclosure say? If the seller checked no, there is no problem, in the case I mentioned about this weekend, and it turns out there were 2 feet of water in the garage, then you could say the seller lied. They are in breach, and yes, the buyer should have the due diligence money returned to them because the seller is in breach. But if they didn't mark any box, they're not in breach. Okay? So whatever those boxes say tells you where there's probably been a problem. If they check no to all these things, and then all of a sudden under the flood thing, they said, oh, I just didn't fill it out. They did that for a reason. So you better do your diligence and find out why before you have your buyer cough up a $10,000 due diligence fee and not get it back. Okay. All right. That's it. Any questions on the residential property disclosure? And we are 6 minutes early, so we have 6 minutes for questions. And there are none. You guys are so smart. So smart.
You're so thorough.
So there is one other form that I could show you real quick since you're so smart. And that's the mineral, oil, and gas rights disclosure. And this disclosure is required to be completed by a seller. And I call this my Jed Clampett disclosure. Oh, sorry.
Carly says we're done.
My Jed Clampett disclosure, it simply says if they're, Carly, she's been so good up until this point. My Jed Clampett disclosure says, that if you're out in the backyard shooting at some game and up through the ground comes a bubbling crude, who owns it? So if the seller is holding their mineral and oil and gas rights back, then if you shot through the ground and oil came up, the oil would be owned by the seller. In most cases, they're going to give you the rights to any mineral and oil and gas. But there are some large developments that were purchased from paper companies like Brunswick Forest, Compass Point, some of the others, that the mineral rights are severed from the property. So in the future, the current owner does not own those rights. It's still owned by the paper company. And that will come out in your title work, in your title search. The closing attorney should find that and tell you that, or tell the buyer that when they go to close. But it should also be disclosed on this disclosure if the seller knows. Okay, so now I'm done. Questions?
Okay.
No? Everybody got it. Everybody's so smart.
I'm sure we're gonna need you when we have moments
And
doing
that's
the
totally
paperwork.
fine. All right, well, thank you all. I look forward to seeing you Wednesday morning at 9 for MLS Basics. And then Friday afternoon at 1 to 3 is CMAs. So comparative market analyses using the MLS. All right?
Thanks, Jody.
Okay, thanks everyone.
Thank you.
See you later.
Something that I don't want to make twice, so then I learned to adapt to